Hello everyone, my name is Disha Mehta, legal intern at LEXIS and Company and a law student at Gujarat University. So today we are going to talk about the landmark judgments or the important case laws relating to the Contract Act. Now this is a mixture of English laws as well as Indian laws and the cases which have happened all over the world. So basically, what do you mean by the term contract? So the Indian Contract Act 1872 was formulated in the year 1872 by the British government. It frames and validates all agreements between the various parties to it. It contains all the provisions relating to the contract laws in India. Now, what is the definition of contract? So, according to the provisions of the Indian Contract Act 1872, the contract is an agreement enforceable by law, is contract. So, what are the landmark judgment or the important case laws relating to the same? So, the first one is Balfour versus Balfour, which was happened in 1919, where Mr. and Mrs. Balfour were enjoying leave in England when the time came for Mr. Balfour to return to Ceylon, where he was employed. The wife stayed back in England for health reasons. Mr. Balfour promised to pay her allowance every month for her maintenance. Mr. Balfour stopped paying when the differences arose and the wife sued her husband for allowance. Lord Atkins explained that there should be intention between the parties to create a contract which was missing in the present case, and the parties shall intend that they shall be attended by the legal consequences. Thus, this was the case law of Balfour versus Balfour. The next one is Mohori Bibi versus Dharmodas Ghosh, which was happened in 1903, which says that a minor mortgaged his property in favor of the defendant and took some money in advance. He thereafter went on to file an action to cancel his mortgage. However, defendant pleaded that he should be allowed his money back, relying upon the section 64 of Indian Contract Act 1872, which deals with voidable contracts. The court held that the contract entered by minor was void ab initio and not voidable. Therefore, the minor is not liable to pay any sum of money advance to him. This was the case of Mohori Bibi versus Dharmodas Ghosh. The next one of the same is Lalman Shukla versus Gauri Dutt, which happened in 1913, where a defendant's nephew was absconded from home. His servant was sent to find out the child. Meanwhile, the defendant through handbills proposed to pay rupees 501 to anyone who finds out the child. The servant found the child but came to know of the offer afterwards. The servant then claimed for the award by filing an action in the court of law, but it was dismissed on the principle that in order to constitute a contract, there must be an acceptance of an offer, and there can be no acceptance unless there is knowledge of the offer. So this is the case of Lalman Shukla versus Gauri Dutt. The next one is Carlyle versus Carbolic Smoke Ball Company, which was happened in 1893, where a company through an advertisement offered to pay 100 British pounds to anyone who infects with the epidemic influenza, cold or any other disease after using their carbolic ball according to the directions. A person who used it accordingly filed an action to recover the amount. The company contended that the offer was not made to anyone personally and hence they are not made to bound by the advertisement offer. The contention was not accepted and it was observed that in cases of general offer, communication of acceptance is not necessary and it can be claimed by anyone who comes and performs the said condition. So this is the case of Carlyle versus Carbolic Smoke Ball Company. The next one is Phillips versus Brooks, which was happened in 1919, where a person named North went to a jewelry shop and purchased some ring in the name of another person, Sir George Bolog, and also issued the check in favor of him by this name. After verifying the address told by North of George in the directory, The shopkeeper allowed North to take a ring with him. After some time, when the shopkeeper discovered of the fraud, North has already pledged the ring in favor of some other person. The shopkeeper filed a case against the other person for this ring. It was observed by the court that the mind of the parties met upon the terms of the sale. The fact that seller was induced to sell by the fraud of the buyer made the sale voidable and not void. Thus, the sale could not be avoided because there was intention to sell and the product to the person present. So this is the case of Phillips versus Brooke. So this is the first part of the video, and the remaining cases we shall discuss in the second part of the same. Thank you.